So for folks that haven't met Dan Reineman, so he's our candidate from Stanford, from the, is anybody else out there, Mary?
No.
Okay, cool. From the Bill Lane Center, and you're going to talk about the Public Trust Doctrine, I suppose.
Yeah, we'll talk about the Public Trust
Cool.
Doctrine. Which doesn't sound like a super enticing title. So the subtitle is Who Owns the Beach and Why you Should Care, and hopefully I can convince some folks to care. So I just want to start by putting what I'm talking about right now, in kind of a larger context, which is that this would be just one lesson in a course which is focused more generally on coastal science and policy and management on the California coast. And really the goal of this course would be to get students to think critically about the connections between science and policy in terms of how we manage the coast, and to do that through essentially a series of case studies on different coastal issues, different coastal ecosystems. Using the California coast is kind of a big case study system, and it's just right there. The Public Trust Doctrine and the sources of legal authority that I'll talk about today. This would be really introductory content in this class. The goal is to lay down some baseline information so that we continue to have conversations about what is the management apparatus that's used to deal with any one particular system, that the students will have some baseline knowledge about where that authority comes from, some of the key terminology, so we can actually talk about the system that the legal system that coastal management is embedded in. And I just want to make one more other note that we try to do this using the coupled social ecological system framework, which is essentially a conceptual tool for helping us think about the relationship between coastal societies and coastal ecosystems, and it helps us recognize that not only do we get good things from the coastal environment, but that we have impacts also, and it's that's not working either. No, I turned it on. And it's management that is helping us decide what those flows look like. And I think an important thing to take away from this is that we talk about managing natural resources, we talk about managing coastal systems. We're not managing the nature, we're not managing the resources, we're managing the people and how they interact with resources. We're managing society and how society interacts with coastal resources. So just keep this in the back of your head as we go through. And I also just want to recognize that this lecture as I'm giving this is titled The Public Trust Doctrine and Sources of Legal Authority. And so that does not sound like a zinger of a captivating title. And it sounds like it belongs in a law school class. So I want to emphasize that I'm not an attorney, but as a scholar of how we manage coastlines, you have to understand that there is a legal system that coastal management happens in. And so you don't need to leave this room wanting to be a lawyer, but there are some things that lawyers know a lot about that the rest of us who are interested in this system should know a little bit about also. And I just want to add that, for the students in the room, that it's actually really empowering knowledge. So if you want to go off and be in environmental science, knowing something about the legal system in that context might help you think about where your data are relevant. If you want to work for the government, it'll let you know where your duty in that agency or that office comes from. If you want to work for an NGO and do environmental advocacy, this is how you will know, whose door to knock on and what you can tell them. So it's important baseline stuff, and so we're going to cover it early in this course, and then we'll be referencing back to it throughout the duration of the class. So that's another quick caveat before I actually start. It's really important to know your audience, and so I'm sorry I haven't got to meet quite everybody yet. But so really quickly, this is a room full of kind of environmental folk. There's always like a show of hands. Natural scientists, social scientists, how about people who want to work in government? Maybe.
Worked in government, maybe?
Worked in government? How about environmental advocacy, environmental law? Maybe? Okay, I'll try to adapt on the fly, but that's really interesting, thank you. I also just want to note that I did throw some numbers up on these, and so by all means you can feel free to interrupt and we'll just move more slowly, and that's great. Otherwise I'll get excited and speed up. Or you can just keep track of those things and we can come back to later. So let's start, we'll start with a little pop quiz. This is actually the classic parlor game that we all play as kids called Who Owns the Land? So I'm gonna throw up some different lands, and we're all gonna vote about who owns it. So if you think you own it, raise both your hands. If you think it's a private entity, organization, corporation, something that's not you, you don't have to raise any hands. If you think it's the state of California, throw up your left hand. And if you think it's the federal government, throw up your right hand. I'll leave the key up there. Okay, you guys ready for this?
Yeah.
Okay, so who owns your yard?
Wait.
I'm a hands down on that one too. Okay, who owns the McDonald's in Camarillo? No one hands, okay. Oh, shoots, you jumped way ahead. How did that happen? Did I hit end? You can't trust me with technology. Not like Sean. How about the library we're in now? Cal State campus. Okay. How about Point Mugu State Park? Left hand, no, that's uncertain. How about Los Padres National Forest? A little right hand going on.
Oh, I guess I should be that.
How about California beaches? So most of these are pretty straightforward. Your yard depends on where you live, and who owns it. Maybe it's the state.
I have a question.
Yeah.
I thought you were voting.
Say, oh, okay, the state.
Just so you're aware, Broome Library has been moved to the private entity of University Glen.
Yeah.
Oh, we tricked him. We tricked him.
So
We tricked him.
It does not actually, the property does not actually belong to the university.
So I should have just stuck with university.
It was a question of paying off the bonds, and so it's been shifted to.
Yeah, and it's actually I wasn't sure about the university itself and when it actually got title to the land from Ventura, who got it for parks from the state.
Isn't that a leasehold from the state?
But that's how he was able to afford his gold LeMay, I think is what
That, exactly, that's how I paid for the gold domain.
So some of these are more straightforward than others, but hopefully the one that is surprising is that number 6, in California, we, the people, the public, are the owners of the tidelands. And so if that fact doesn't blow your mind a little bit, hopefully that's okay. But hopefully by the end of today, you at least understand how that came to be and why it's both interesting and important, and why if we're talking about coastal management in California, it's something we need to have in the back of our minds. So our ownership of the beaches derives from something called the Public Trust Doctrine, which says that the sovereign holds the tidelands and submerged lands and resources in trust and manages them for the benefit and use of the public. What the hell does that mean? Saying that we own the beaches and then pointing to this is like saying that we're independent and pointing to the Declaration of Independence. Who's the sovereign? What's in trust? So we just break this down and go through this. So who's the sovereign in this example? Any guesses? It would be the entity that has authority, and in that case, it's the state of California. So yeah, the state. How about in trust? We talk about kind of like trust, the idea of trust, something that pops up occasionally in private life. So to hold something in trust is to be given responsibility to manage it on behalf of someone else. So maybe you have an elderly grandparent and they are no longer in a fit state to take care of their finances, and so you would be made a trustee for their assets and manage them for them. So in this case, the state has been made the trustee of these resources for the public. How about tidelands, submerged lands, and resources? Any ideas of what those are? Where's the marine biologists in the room? Where's the tidelands? Sean knows. Kiki knows.
Near the coast?
Near the coast. So if this is the coast going up, and this is sea level. Sea level obviously goes up and down a little bit. I'm not a very good artist. That's up and down of sea level. What's making it go up and down every day?
The tides.
It's the tides, right? So if this is medium tide and this is low tide and this is high tide, the coastal intertidal ecologist will know what this stretch of the coast is called. It's the intertidal zone. So these are the tidelands. This is the upland. See clear writing. Tidelands. And then out here, we might call this a subtidal, sublittoral, but this is the submerged lands. How about resources in the tidelands and submerged lands?
Food.
Food. What else? What things? Resources that are down there? Minerals. How about the water itself? Also a resource. So this is. We'll come back to this a little bit. This is our Cisnessa tidelands. And then it says that the Public Trust Doctrine says that the state is going to manage these things for the benefit of the public. Clicker. There she is. So one of the reasons that coastal management is interesting in California is because the outcomes and the benefits and the impacts that we were talking about earlier, they're dynamic and they're complex and they're constantly changing, and the state is managing them for us as a result in part of this doctrine. So just to take a quick example, so this is Broad Beach, Malibu. It's about 20 miles down the road. So on one side of the image, big fancy houses. On the other side of the image, public beach. It's somewhat ironically named Broad Beach.
That's
The beach,
right.
it used to
Yeah.
be broad.
That's right.
Kiki can tell you all about that. And you see all these rocks that are piled here. These are rocks that have been put in place there by the homeowners to protect their houses. So are the rocks on the public beach? Are they on the public tidelands? Are they on the private property? What happens if the rocks make the beach erode and the sand goes away and the beach gets smaller? Whose fault is that? What if sea level rises and the beach disappears and they need to put down more rocks? So these are really interesting questions, and they're the kinds of questions, the kinds of cases that we'll talk about in this class, and the answers aren't always easy, and a lot of them are things that we are constantly grappling with in California. But it turns out that dividing line, this line right here, between the state tidelands and the publicly owned part of the public trust resource and the upland, which can be privately owned, the location of this line really matters in this example. If you want to go to the beach, if you want to play on the beach, if you want to protect your home with giant rocks, the location of this line is really important. And it's a really dynamic system. Maybe the line is going to move. What happens then? Really interesting questions. And so if we want to understand how this fits together in the system, we have to understand something about the public trust doctrine, and then the sources of legal authority, the laws, the regulations, the institutions by which we as a state are managing this system. So in this course, those are the kinds of questions we're going to explore. These are the kinds of resources that we're going to be talking about. These are the kinds of issues and questions and authorities that will be relevant for conversations. And so the takeaway from our time together in this brief, time flies, introductory lecture is really about the factors that underlie how we understand and manage this system. So just some take-homes that I want you to leave with. The public owns the tidelands, the state managed them for us, and this management relies on its legal authority. And in the case of the tidelands, we saw that coming from the public trust doctrine. But legal authority, laws, they come in different shapes and sizes, so we'll use the public trust doctrine as a way to just talk about some other flavors of laws and how they relate to the coast. And hopefully understand that these relationships between how people manage ourselves and how we interact with ecosystems, they mean understanding that management process, and that's built on these legal structures. So we talked a little bit about the public trust doctrine, which is common law. We'll come back to that, but there's some of these other flavors of law, and hopefully by the end of today you'll have a little bit of a better sense of how these different things fit together in terms of the way we manage the coast in California. But first, since I'm going to throw these terms around, I want to make sure we're all on the same page. Just a really quick review of how the U.S. government is organized. So we have the three branches. We can all name them. This is as embodied in the building. So the legislative branch, executive branch,
judicial.
And the judicial branch, and they fit together, and there's various checks and balances. They're all really interesting and important. Science will tell you which one makes the laws. Yeah, but so what's interesting is that if we think about, if we define law a little more broadly, there are sources of legal authority that derive from each of these branches. We'll talk about that a little bit today. And also, just as a quick note on the U.S. system of government writ large, we also are organized into levels of government. So we've got, in Washington, D.C., the federal government, we've got, in our state, the California government, and then at the local level. And there are various iterations of those branches at each level. So there's the federal Congress, or there's the Congress, there is the president, there are the federal court, the Supreme Court system. At the state level, there's the governor, the state legislature, the state court, going up to the state Supreme Court, and then at the local level, we've got the same structures. Okay, that's just a quick review civic. So, our discussion of the Public Trust Doctrine really starts with the common law, and this starts in the course and in the courts, because another way of thinking about the common law is as case law or judge-made laws, two other ways that it's described. And this means that this is a law that is shaped on the precedent of what has been decided in the courts in the past. So the way that judges make decisions is they look at a new set of facts in each case, and they decide based on the cases that have come before whether or not those facts meet that case, how those facts relate to the cases in the past, and they make a decision based on that precedent. So common law is the basis for a lot of laws in the United States, or much of our legal system is built around a common law history, what I'll talk about in just a moment. And so some of the things that are common laws that have been decided in the courts over the years are things that we really take for granted, don't even think about them necessarily as laws. But this is their origin. And I think just one great example is when you get arrested. I haven't been arrested, but I've seen this on the television. Police read the suspect their rights, right? You have the right to remain silent, you have the right to an attorney, everything you say or do may be held against you in a court of law. So those are called the Miranda rights. Are you guys familiar with the term Miranda rights? So the Congress never wrote a statute and sent it to the president. It was never signed into law that the police must read those rights. That's a result of a court decision. There's actually Miranda was a guy, Mr. Miranda, in 1966. The evidence against him in court was thrown out by the U.S. Supreme Court because they said he didn't know his rights. And so to address the situation, ever after the police read a suspect their rights so that anything they say or do can in fact then be used in the court. So that's just one example of a common law that we've all dealt with. And so because common law is built on the precedent of cases that have come before, it has a rather long history. And in the case of the public trust and environmental law, it can all be traced back to this guy. This is Emperor Justinian in Rome, Justinian, son of Justin. And in the mid-first millennium, 535 AD, he actually set about writing down all of the common laws that they had in Rome. And I'm going to read this one because this is awesome. In terms of coastal resources, he wrote, "By the law of nature, these things are common to mankind, the air, running water, the sea, and the shores of the sea." So in 535, Justinian is recognizing that the sea, the fish in it, and the beaches are common to all mankind. In other words, they can't be owned privately by anybody. So 535 AD. He also codified a lot of other common laws in terms of property rights and criminal procedure, and those things eventually spread out through most of Western Europe. Not so much because Western Europe was like, oh yeah, Rome, they had a really great idea about how we should have a legal system, as Rome just kind of went out and conquered everybody. And so the Roman common law legal system spread out through Europe. And the Public Trust Doctrine, as set down by Justinian, also dispersed at this time. And one of the places it ended up with was England. And England started with the Roman version, that the sea and the fish and the shore is common to everybody. And it's in England where it evolved a little bit, and they added that situation of the state managing those resources in the interest of the public. And can you imagine why that evolution might have happened? Why do you take a resource that can't be owned by anyone, free to everyone, and why suddenly might you need to have someone in charge of how it's managed.
King.
Wasn't just a king, but that is kind of where we get the concept of the sovereign, right? What might happen with a resource if it's free to everybody, no one can own it? That's basically a really great example. So I wasn't in, first century England. There's no court cases that are written down that survive, but you can imagine that resources that are common to everyone, there's going to start being some competition. There's going to start being some conflict. So at some point, the English crown decided that, yes, these things are still owned by everyone, but we're going to actually have to manage them a little bit, otherwise they might disappear or the conflicts will become problematic. So of course then the English, they spread their version around the world, including to North America, where we are, and then in 1776 we said, you keep your king, we're taking your language, we're taking your bizarre system of measurement, and we're taking most of your common law legal system. And so the Public Trust Doctrine, as the English had formulated it, essentially migrated to the United States at that time. So here in the United States, the Public Trust Doctrine, a common law, has continued to evolve. So I'm just going to give you two examples of how that evolution has been shaped through court cases. Common law originates in the courts. One is a decision in 1892. This is when the Illinois Central Railroad wanted to build their tracks through Lake Michigan. And the Supreme Court said, well, you can't do that because once you get inside into the beach and in the lake, those are resources that belong to everybody. And we have an affirmative duty to manage those resources so that people can derive benefits like navigation, commerce, and fishing. And so here you see, in addition to the Public Trust Doctrine saying that we all own them and the state manages them in trust for us, now you have the Supreme Court of the United States calling out some of the specific benefits that the states need to be keeping in mind when they are making decisions about how to use those resources. In a more recent example, the California Supreme Court ruled that the city of Los Angeles couldn't divert water from Mono Lake to feed its thirsty growing population. Mono Lake is really neat. It's about maybe a 6-hour drive. It's almost exactly due north of here, same latitude. And it's a really interesting environment. The birders in the room will know about phalaropes and other really neat species. It's really, you should totally go there. I've never been, but I'd really like to go. Mono Lake. And by diverting water from Mono Lake to Los Angeles is having a negative impact on the wildlife, on the natural resources of the lake. And so even though Los Angeles had a permit to take this water, the California Supreme Court ruled that in addition to navigation, commerce, and fishing, the state also had an affirmative duty to manage this public trust tidelands. And they added to navigation, commerce, and fishing, they added preservation of those lands in their natural state. And some other really interesting language about wildlife preservation. And so here you see that the public trust has now evolved to include not just navigation, commerce, and fishing, but sort of a conservation ethic. And so that only just happened in 1983. And so as the interests of people, as our effect on the environment has changed through the centuries, you see the common law evolving, and this is now the new precedent. But what's interesting is because it's based on individual court cases, there's no one federal version that absolutely applies to everybody. So the result of this is that different states define their public trust area, their public trust resources a little bit differently. So we talked about how important that line was. That line is drawn, the line between the state public trust tidelands and the privately held uplands. This line has different definitions in different places. So in California, where we are, in Alaska, much of the southeast, that line is at mean high tide, mean high water. But in other places like Washington, Louisiana, and and Hawaii, they actually get more to the beach. So in addition to the intertidal zone, they also get essentially the supertidal zone, the dry beach. Some other states get less. And so, I was saying that difference matters, and I'll just give, this is a really recent local example of why this difference matters. And so this is an article from CNN for just last month, drawing a line in the sand in Malibu. And I'll just read the caption because it's great. Lucia, 6, looks on as a security guard asks her mom and a friend to leave the beach. So, are you kidding? But
That's Malibu.
it's Malibu, right? And so the people in Malibu have a very clear recognition, the private homeowners, of where that line is, and they actually hire private security guards to enforce that line. So if you are in the wet intertidal zone, you can hang out on the beach. If you're in the dry sand, they'll try to kick you off. But as you can imagine, it doesn't get enforced perfectly. And this article goes on to say that of the two women at the beach with the kid, one of them has actually worked for the Coastal Commission, who's the agency who manages this. We'll come to them in a minute. Someone who knew exactly where the line was and tried to explain to the security guard where the line was, and it didn't quite work out. So,
Malibu.
So Malibu. So this is happening locally, and it's still happening. Even though the public trust has been around a long time, it's no surprise that we, the public, on the beach, this is happening. So by now we've seen the public trust owns the tidelands, the state manages them in our interest. Management relies on its legal authority. So now I just want to talk about some of the other different places where that legal authority comes into play in terms of how we manage coastal resources in California. And this will help us understand a little bit more of the complexity of how we manage this really complex dynamic system. And we can actually keep using the public trust doctrine as a way, as a lens to look at some of these other issues. We're at 27 minutes, but we started late.
It's all good, it's all good.
So I keep saying that the coast is a complex system and there's lots of different resources and we get different things. So if we're just thinking about some of the beneficial things that we get from the coastal systems, like resources that we benefit from, just throw up a few, name a few. What are some things that we as a society benefit from on the coast? Coastal resources.
Surfing.
Surfing. So what's the resource in that case?
Waves.
Waves. Okay, what are some other things?
Sharks.
Sharks.
Nice!
Both for shark diving, and there's still a few shark fish. What else? So fisheries, waves, recreation, which it kind of depends on what kind of recreation you're doing, what the resource is. Tourism, oil and gas development, lots of different things that we benefit from. So I just threw up a few: fisheries, pieces, tourism, oil drilling. So got a lot of that out here. About the ways that we impact the coastal system. So you can think of it as a resource like a source of resources, a system with resources that we draw from. But you can also think of it as a repository for the resources that we don't want. So what are some of the things that we do that have an impact in the coastal zone?
Overharvest.
Overharvest. So we overfishing, that's a problem.
Aquaculture.
Aquaculture can be a really interesting and increasingly complicated problem in California. Runoff is a great one. I threw up a few. But we also, so there's I actually don't have a runoff image, but we treat our sewage and we dump it
That's
in
good. That's a good one. That's a good shot.
Interesting, when I Googled images of coastal resources, one of them is, if you just Google that, eventually you get down to Sean reading a biology book underwater. I'm not sure what the impact is there. But we build on the coast, we develop in the coastal zone, we use water to cool our power plants, we create our ports and harbors. And does anyone have a guess what this is, what this map is?
Fiber optic cables.
Yeah, fiber optic cables coming ashore. So it's a map of the Trans-Pacific Fiber Optic Cable Network. This is what brings us the internet. So I should just use this as a quick example to talk a little bit more about sources of legal authority. So I think maybe objectively we'll agree that the internet is a valuable thing to have in our society. But to get it here, these cables, which go all the way across the ocean, they have to come ashore. They cross the submerged lands, they cross the tidelands. So they are potentially having an impact on our public trust resources. And so the state has to decide what to do, has to balance the benefit of having the cables versus the impact that they have. And when Justinian was putting down the Public Trust Doctrine in 535 AD, he wasn't thinking ahead to Trans-Pacific fiber optic cable networks. So there's got to be another way that we can think about how we manage this. So the state of California, in its wisdom, the legislature passed a different kind of law, which is a statutory law. And they decided that what the state really needed was an agency that could take care of these public lands. So the state is charged by the Public Trust Doctrine with managing these lands, but it's a really complicated environment. There's lots of different resources. So the state passed a law to help the state figure out how to deal with these different kinds of resources, these different kinds of benefits, these different kinds of impacts. So the state passed a law, it's Public Resources Code 6009, you don't have to worry about that, but this is a law that the legislature voted on, that the governor signed, and it created the State Lands Commission. And so the State Lands Commission is a commission that recognizes, it's an agency, a state agency, that because of the Public Trust Doctrine, they have been given the duty from the state to manage the tidelands. And so one of the things that they deal with is how and when and where to allow for trans-Pacific and fiber optic internet cables to come ashore. So, as an example, the statutory law passed by the legislature to create an agency to help the state deal with this situation. And of course, they also deal with other kinds of coastal development situations, for example, the construction of a harbor, which also requires the use of a public land. And in that case, they have to do that balancing between, well, people will benefit from the presence of the harbor, and even though it might have an impact on the coastline, that's the kind of thing that, those are the kinds of decisions that they make. Get all that?
We use Catalina as their banner.
Yeah,
Sure, why not?
The other option, there was a couple other different men, but I like the casino in Catalina. That's a good decision. So we'll just take one more example with the time that we have left. This kind of brings us full circle back to Malibu. So if you look carefully at the epic row of mansions, it's hard to see where the public will get from the road on the other side to the beach. Right? And what's the point of having a public trust resource that the state manages for our benefit if we can't get to it? There certainly isn't going to be, we're not going to be able to avail ourselves of the fishing and the commerce and the navigation if we can't get there from the road. We certainly won't be able to enjoy the wildlife that may or may not be preserved there. But in California, we have the right of access to those tidelands, and that right is actually guaranteed in the state constitution. So this is really bitchin'. Article 10, Section 4 of the California Constitution, I'm gonna read it because it's that great. It says, "No one shall be permitted to exclude the right of way to such water," tidelands. In other words, no one can prevent us from getting there. "And the legislature shall enact such laws as will give the most liberal construction to this provision." In other words, the Constitution is instructing the legislature to pass a statute that says, make a strong statute to protect this right of access for the people. "So that access to the navigable waters of this state shall always be attainable for the people thereof." So that always is really great. It means that now and forever, the state has a duty to protect our ability to get to these resources. So that's really great, but it's also, you see, this is a very complicated system. There's lots of benefits, there's lots of different impacts. These private property owners own this private property. The Constitution doesn't say when do you get to have access. It doesn't say anything about where you get to have access, how much we need. You can't just go to the doors of these houses and say, "Oh, the Constitution says that I can go to the beach," and so it won't work. So this is just another example of statutory law that the Congress, the state legislature, as instructed by the Constitution, passed a really excellent law trying to provide that liberal interpretation of the coastal access provision of the Constitution. And so the state passed the California Coastal Act of 1976. And it has some great protections in it in terms of how we manage coastal recreation, coastal wildlife. It also has a whole chapter devoted to coastal access. And to manage that access, it creates another agency, the California Coastal Commission, and it's the Coastal Commission's job to work with the state and to work with local governments to make sure that that access exists adequately for people like us when we want to get to the coast. And I'll just say we talked a little bit about that balancing between benefits and impacts. There's another great section of this law which is, they call it the conflict busting provision. It says when a conflict exists between, say, private property and access, that the legislature, the commission must favor the option that is most protective of significant coastal resources. And so that's a good bonus. But you can imagine how maybe access is a problem in that circumstance. So if it's a really sensitive habitat that Sean and his guys have just finished restoring, then maybe having too much access there could actually be a bad thing. So these are the kinds of decisions that the Coastal Commission, based on the statute, as instructed by the Constitution, are dealing with on a fairly daily basis. Just a quick note, we talked a little bit about the evolution of the Public Trust Doctrine as a common law that gets updated through cases over the years. Other kinds of laws can evolve as well. Constitutions get amended, new statutes get passed in each session of the legislature, although not so often these days. And so this is just an example of the California Coastal Commission realizing that it needs to start thinking very carefully about how sea level rise is going to affect coastal resources and things like public access. And it's starting to create some guidance so that at the local community level, the community governments, local jurisdictions like Ventura and Oxnard and Malibu can do a better job managing their coastal resources in the face of a changing environment. So just really quick wrap up. So we've seen the Public Trust Doctrine. We, the people of California, the public, we own the tidelands. The state manages them for us in our best interests, and that has evolved. What our interests are, the recognition of different kinds of things that we have an interest in has evolved through time. And the state relies, its ability to do this management relies on a set of legal authorities ranging from common law, which is passed and updated based on precedent through the court system, based on statutes, and also in California, in terms of public access, our Constitution. And these are the kinds of things we need to be thinking about if we want to understand how we, California, are managing our coastal system. And particularly in light of changing environmental conditions, how these things all fit together is, understanding how these things fit together is going to be predicated on understanding how these laws inform the management here. So if you kind of think about what all this means is that our coupled social ecological system framework, it's not nearly this simple. I know this looks pretty complex, but you call ecosystems on one side, societies on the other. It's not just these two big fat arrows and kind of management. It's actually this really complicated thing. Different management authorities are managing different benefits, different impacts. And so throughout the rest of this course, we're going to be kind of picking arrows off that list, the different issues, different systems on the coast. We're going to explore those different legal authorities that help Californians deal with those various impacts, and how that may or may not change through time. So hopefully now when you go to the beach, you will appreciate it a little more because you know that it's yours. And you know that by visiting it, you're exercising rights that are guaranteed both in the common law and the statutory law and in the state constitution. And so thank you for your attention, and let's talk about this. And that was pretty good. How are we doing on time?
That's good.